self-confidence and recognition that it was an equal nation. Now, some of the scholars then write about, well, how did the Japanese think about international law? I mean, was it accepted willingly? Did they embrace it? And many Japanese scholars said international law seemed natural to the Japanese during the Meiji period because they found links between the Neo-Confucianist ideas of universal justice, the way of heaven, and the natural law roots of the law of nations. And some of them found international law to be attractive because of this idea of equality of states, that it would protect small nations against bigger nations, and therefore, Japan against China, perhaps. Other scholars, of course, were more cynical, but there was sort of an attractiveness of international law, and Japan engaged in a series of arbitrations during this period, more than any other country during that time. 4 or 5 international arbitrations in the late 1800s, early 1900s. Then in 1903, one of them didn't work out the way the Japanese wanted to, so they sort of became less enchanted, but at least for a time they were active in accepting and utilizing international arbitration through the Permanent Court of Arbitration. The 1903-1905 case involved interpreting the revised unequal treaty, and Japan felt that the ruling didn't accept the fact that it had been changed, and was deeply disappointed by that. Now, a lot of the scholars, the current Japanese scholars, when they write about this period, they use the term saying Japan had scrupulous observance of international law principles during this Meiji period and up until the military time in the 1930s. And you see that word scrupulous observance in a number of writings, including that of Judge Oda and Judge Kawada. And I'm always a little sort of perplexed by that, because they point to some adherence to the laws of armed conflict during the Sino-Japanese and Russo-Japanese War, but of course there were a lot of other things that were going on that probably wouldn't be viewed as scrupulously observing international law. But of course one of the problems is what was international law really? And of course Japan's movement into Korea is still the cause of much concern among Koreans. The Koreans opposed the Protectorate Treaty and then the annexation. The United States, of course, was providing some support for Japan during that time. This is a quote I always sort of scratch my head about, that Secretary of War William Howard Taft, speaking at the Japanese Chamber of Commerce in Tokyo in 1906, says, "We're living in an age where intervention of a stronger nation in the affairs of people unable to maintain a government of law in order to assist the latter to become a better government becomes a national duty and works for the progress of the world." This was right after the Japanese had accepted U.S. Occupation of the Philippines, while the U.S. accepted Japanese occupation of Korea, and basically they were dividing up the world. The Hague conferences were taking place during that time. These were very important international conferences, really the first global conferences that we see to develop the laws of armed conflict. And Japan was one of the 26 countries at the 1899 conference and played an active role in it. The Koreans tried to send delegates to the 1907 conference. Japan protested vigorously, and things did not turn out well for these Koreans, or Korea generally. And Japan then forced the Korean emperor to abdicate because he had the audacity to send this mission to the Hague Conference, and the Japanese, of course, were treating any Korean resistors very brutally during that period, and then finally in 1910 annex Korea altogether. I've been working with scholars to try to understand this period, Korean and Japanese scholars, and the the Japanese scholars tend to acknowledge that wrong things occurred, but are unable to say that this was illegal because, according to their view, international law had not evolved to the point where using force against a weaker state was improper or illegal. And so then, of course, Japan goes into its military phase more fully in the 1930s, and great suffering is caused in the region. So as Judge Owada summarizes this period, he says that if you start with the Commodore Perry landing, you have first exposure and absorption, then adherence and application, and then finally repudiation and realignment, repudiation of international law and realignment. Japan leaves the League of Nations and violates the various Kellogg-Briand Pact and so on. Judge Owada's summary of all this is interesting because he says that excuse me, Japanese scholars and lawyers, sorry, tend now to interpret and apply international law as a pure analytical process rather than as a process of testing the validity of the law in the context of the social reality in which the case in question has to be weighed. So he's going back to this idea of the scrupulous adherence idea, and he's saying that sometimes there's sort of a formalistic approach. He criticizes this as excessively legalistic and technical approach to international law, and that sometimes prevents the more pragmatic and flexible approach that might be useful. Now, just to close, we're entering a period where there's lots more international mechanisms and tribunals and opportunities for dispute resolution. And so after this 1903-1905 arbitration, Japan sort of pulled back from arbitrations and court decisions, but they seem to now be back in the game a bit. There was a case brought regarding the bluefin tuna brought by New Zealand and Australia that was ultimately resolved on a technical procedural ground by the arbitral tribunal that was set up, and so the merits were never reached on that issue, and the Japanese wanted to prevent the law of the sea tribunal procedures from being used. But more recently, Japan itself has brought claims against the Russian Federation, 2 cases in 2007, to the International Tribunal for the Law of the Sea. And Japan, of course, has a judge on the Law of the Sea Tribunal. So it seems open, perhaps even eager, to use the Law of the Sea procedures and the tribunal, as we saw in these 2007 cases. And now Australia has brought a case involving whaling, challenging the Japanese whaling in a case before the International Court of Justice. So Japan has accepted the compulsory jurisdiction of the International Court of Justice, so this is something that obviously shows its commitment to international law, and this is an example of a case that apparently will go forward and reach the merits on the legitimacy of the Japanese scientific whaling. Japan has extensive maritime claims to disputed islands and to continental shelf areas. There isn't time to really go into this, but certainly Japan is trying to use concepts in the Law of the Sea Convention to its advantage. So as we look at this sort of sequence of events over the last 150 years, What does it tell us about international law? Did Western international law just go to Asia and become accepted, or did the international law change? Was there a merging of international law? This probably requires some further study and analysis, but certainly the Asian approaches to international law are being voiced more these days. And we're going to see international law, I think, continue to evolve and accept Asian ideas as well as the international ideas. So anyway, thank you for listening to my thoughts, and I'd be happy to answer any questions if anybody has any.
Well, we certainly have a little time, so floor's open. Tom.
I have a comment and a question, just in terms of your last point. I think if you look at Japan and the other countries in the region, you see that the Asian countries are in fact the most Westphalian of states.